So you've been charged with a felony. The arraignment has occurred. You were pled not guilty. You have gone to the readiness conference and the DA says no deals. That's all there is to it. You're facing a substantial prison term and they say no deals, and there's no way this case is going to be negotiated out. So the next step in the process is called the preliminary examination or the preliminary hearing. What is it? Well, the preliminary hearing is where you are present, your attorney is present, the district attorney then puts on a case in front of a judge. You actually go into a courtroom, they can either do the preliminary examination in that courtroom that you went to, or they'll send you out to a different department. So it's before a judge, and it allows for the district attorney to put on evidence. They have to call witnesses. There are some differences in a preliminary examination between a trial and a prelim. It's sort of a mini trial, but it's only before a judge, and it's only to establish probable cause that in fact a crime has been committed within the jurisdiction and that you are the person that is likely to have caused that crime or committed that crime. So what happens? Well, they call their witnesses, and certainly your attorney gets to cross-examine them and point out holes in their story. You've obviously reviewed the police report. You kind of know what evidence they have. Now, the difference here is that the prosecution doesn't have to give you all of the evidence before the preliminary hearing, because their burden is just to put on enough evidence to show that the probable cause exists. This is where prosecutors play their game, because they don't always give all of the evidence. They sandbag, they keep things back. And only after the preliminary examination and you're bound over do they have an obligation. Well, take that back. They do have an obligation for the entire case to show any evidence that either proves or disproves that you have committed this crime. But they don't always do it. Certainly not in a timely manner, certainly not in a manner that I am satisfied with. So they put on this case. Well, one of the differences between a preliminary hearing and a trial is they don't have to bring in witnesses that actually said things in the police report. They can bring in the police officer under a thing we call Proposition 115 and allow the police officer to testify to what a witness told them. I particularly disagree with this. I think if you're going to put on a preliminary hearing and that you're going to put on witnesses, you put on the witnesses that said what they said. But the law is what it is. So Proposition 115 allows them to bring in police officers, and sometimes police officers can even testify as to what the medical examiner found, so they can actually give medical testimony on what the medical examiner found and why that relates to the case. But the purpose of the prelim is threefold. One is it's to poke holes in the district attorney's case to sort of show them that the case isn't as strong as they thought it was going to be. Two, it can be used as a discovery tool. And what that is that there's certain information that might not be in the police report that the officers are going to come out with, or whatever witnesses that are on the stand are going to come out with. So you might find certain things out. And the third is just to find out how strong and how credible those witnesses are. So our position might change based upon whether or not the witness is credible, how they hold up on the stand, how they hold up under cross-examination, how they appear, how they testify. There's a number of different things that from a police report you really can't tell. Until you get that person or that officer on the stand, you're not sure how strong their evidence is. So remember, it's about poking holes in their case, it's about finding out what evidence they have and discovering future evidence, and it's about ascertaining the credibility and the appearance of the witnesses. But ultimately, the preliminary examination is about showing that they don't have a prima facie case so that you can get the judge to dismiss the charges at the preliminary hearing. Sometimes that's successful, but remember, most of the time it's not. It's a very, very, very small burden. I mean, where if you say beyond a reasonable doubt is here, preliminary hearing is here. It's simply just probable cause. And many, many cases, in fact, nearly all of them are bound over. However, if you're charged with multiple offenses, the district attorney has to put on a case that establishes probable cause on each and every charge. So it could be, if you're facing 15 different charges, that you have some of them dismissed, or all of them dismissed if we're extremely fortunate, but some of them dismissed at the preliminary examination, which sort of helps us down the line as far as trial is concerned. Sometimes DAs get all excited when they say, hey, I've got your guy on 30 counts of this, how about he only plead to 2? Well, guess what? If with the preliminary hearing we can get a bunch of those dismissed, well, their case becomes, or at least their bargaining power becomes somewhat weaker. So that's what happens at a preliminary hearing. I'm able to ask questions, I'm able to cross-examine, get more evidence out, and be able to get a feel for the witnesses. So if you have any further questions, or you or your loved one is going to be facing a preliminary hearing soon and you need to hire somebody and you're not satisfied with the representation they've gotten, give me a call. We'll talk about it, find out what's going on, and maybe we can help out. Thank you very much.